Welcome to The Deep Dive. We're the show that takes complex source material, dense reports, legal docs, and really boils it down to the essentials for you, giving you that shortcut to being properly informed. And today, wow, we have a really specific, really fascinating scenario. We're diving deep into the UK legal system, but through quite a dramatic lens. We're exploring a detailed, hypothetical, but legally grounded argument. Imagine a devout Christian challenging a potential government-mandated digital ID. And the grounds, purely theological. They interpret this ID as the biblical mark of the beast.
Yeah, it's a stark collision point.
Exactly. This isn't just abstract theology. We're looking at a real potential conflict between state policy, maybe something like the Digital Identity and Attributes Trust Framework, and a deeply, deeply held religious conviction.
A conviction that dictates exclusive loyalty to God.
Right. Think Exodus 20, the first commandment. And this believer sees the ID as, well, fulfilling prophecy from Revelation 13. Complying means, in their view, risking spiritual harm, maybe even eternal harm.
A profound conflict.
So, our mission today is super clear. We want to unpack the legal arguments. How could someone refuse this ID based purely on religious discrimination grounds in the UK? What tools, what laws, precedents, procedures are actually available?
That's the core question. And we're focusing mainly on two key pieces of UK legislation.
Which are?
Primarily, the Equality Act 2010. That's the bedrock of anti-discrimination law here. And alongside it, the Human Rights Act 1998, which brings in fundamental rights like freedom of belief.
Okay.
By dissecting this, quite specific scenario, we actually get a fascinating glimpse into how the UK legal system tries to accommodate very particular, even interpretive religious beliefs. It's quite surprising, really.
Let's get into it then. Section 1, laying the groundwork.
Okay, so first things first. To make any claim of religious discrimination stick in the UK, you absolutely have to establish the legal foundation. The claimant needs to anchor their entire case in the Equality Act 2010.
Right.
Our sources point directly to Section 10 of the Act. That's the bit that defines religion or belief as what's called a protected characteristic.
And critically, this protection, it has to cover the entity actually pushing the digital ID, right?
Right.
Which would presumably be the government or some public body.
Absolutely. And the Act does cover them. Section 29 makes it very clear that the rules apply to public authorities, government departments, agencies, anyone rolling this out.
Okay, good.
And maybe even more important for this scenario is Section 29, subsection 8. This covers access to goods and services.
So if the ID becomes essential for, daily life.
Exactly. If you suddenly need this digital ID to open a bank account or access your NHS records or even, say, get a new passport, well, if you can't get one because of your religious belief, the government is effectively restricting your access to essential services.
Even if the policy itself seems neutral on the face of it.
Precisely. It's a neutral policy with a discriminatory effect on a specific religious group. That's key. Now, the Equality Act provides, broadly speaking, 4 types of protection. There's direct discrimination.
Which probably isn't the main issue here.
Unlikely. That would need proof they're targeting Christians deliberately. Much stronger, usually, is indirect discrimination. That's where we'll spend most of our time.
Okay.
Then you also have protections against harassment and something called victimization, which is basically penalizing someone for bringing a discrimination claim.
And you mentioned the Human Rights Act, too. How does that fit in?
It acts as a powerful backup, reinforcing the claim. The Human Rights Act 1998 incorporates the European Convention on Human Rights into UK law. And Article 9 is crucial here.
Freedom of religion.
Freedom of thought, conscience, and religion, yes. But critically, Article 9 protects not just holding the belief privately,
but acting on it.
Exactly. It protects the manifestation of that belief. In this scenario, the act of refusing the digital ID is the physical outward manifestation of that sincere conviction about the mark of the beast. And Article 9 says the state generally can't interfere with that manifestation.
Okay, this is where it gets really, really interesting, isn't it? The core challenge. We're talking about a secular legal system. How does a belief, especially one based on a specific theological interpretation of Scripture, not like a universally agreed doctrine, how does it actually get legal protection?
That's the absolute first hurdle. And you're right, it's nuanced. The law doesn't and can't judge whether the belief is objectively true or rational.
It doesn't care if the judge thinks it's the mark of the beast.
Not at all. The focus is on sincerity and whether the belief meets certain legal criteria. The key case law here is Eweida v. British Airways.
Oh yeah, British Airways employee, the cross necklace case. I remember that.
That's the one. She wanted to wear a visible cross. BA's uniform policy forbade it. The UK courts initially ruled against her, but the European Court of Human Rights ultimately found in her favor.
And that set a precedent.
A huge one. It established the test. For a belief to be protected under Article 9, and by extension the Equality Act, it must be genuine and deeply held.
Genuine and deeply held. So our claimant, the person refusing the ID, has to show their conviction is as sincere and fundamental to them as Ms. Eweida's was to her.
Precisely. They need to convince the court that refusing the ID isn't just a preference or a political protest, but a core requirement of their faith, stemming from that deep conviction.
That feels like a high bar, though. Especially if a judge sees this specific interpretation, the mark of the beast thing, as, a bit out there, maybe extreme.
It is a high bar, and that's where the Granger criteria come in. These criteria emerged from another case, Granger Pay SC v. Nicholson, and they help courts assess whether something qualifies as a protected philosophical belief under the Equality Act, which has similar requirements to religious belief.
Okay, so what are these criteria? Let's break them down.
Right. There are 5 main points the court looks at. First, it must genuinely be a belief, not just an opinion or viewpoint.
So more than just thinking digital IDs are a bad idea.
Much more. Second, it must relate to a weighty and substantial aspect of human life and behavior. Beliefs about fundamental existence, purpose, morality usually qualify. This one, concerning salvation and allegiance to God, clearly does.
Makes sense.
Third, it must attain a certain level of cogency, seriousness, coherence, and importance. It can't be completely illogical or based on, say, information the claimant knows to be false, but it doesn't have to be scientifically provable.
Okay. Coherent, serious.
Fourth, and this overlaps a bit, it must be worthy of respect in a democratic society. This is a key one.
And that's the tricky one, isn't it? How does a belief about an apocalyptic mark, which some might dismiss as paranoia, pass that test?
It passes because the test isn't about whether the belief itself is respectable to everyone, but whether it's the kind of belief that deserves protection in a pluralistic society. Crucially, it mustn't be incompatible with human dignity or conflict with others' fundamental rights.
So refusing an ID doesn't harm anyone else directly.
Exactly. And critically, it's rooted in the core canonical scripture of a major world religion, the Book of Revelation. Even if the specific interpretation, like dispensationalism, is held by a subset, the source text itself is undeniably central to Christianity.
So the court respects the sincerity and the connection to the text, not necessarily the conclusion.
Precisely. The court isn't asked to agree with the prophecy, just to accept that this is a sincere, coherent belief derived from a recognized religious text and therefore worthy of respect in a democratic society. Sincerity trumps popularity.
Okay. So sincerity is the cornerstone. What kind of evidence would you actually need to bring into a courtroom to prove that this conviction is so deep you'd risk, eternal damnation over a government ID?
The evidence needs to be pretty robust. First, you'd need compelling biblical exegesis. The legal team has to clearly show the link the claimant is making between the features of the proposed digital ID and the description in Revelation 13.
Like the buying and selling aspect.
Exactly. Revelation 13, verse 17 says people couldn't buy or sell unless they had the mark. The claimant needs to demonstrate how a mandatory digital ID, potentially needed for banking, employment, maybe even food purchases eventually, mirrors that economic control identifier. Then you bolster this with theological expert evidence. Affidavits, maybe testimony from theologians or scholars. Our sources mention referencing established commentators, perhaps people like John Walvoord or Tim LaHaye, whose works popularized this kind of interpretation.
So showing it's not just one person's unique idea, but part of a known theological stream.
Precisely. It demonstrates to the judge that this isn't some sudden invented objection, but a documented, albeit specific strand of Christian eschatological thought.
And finally, the personal element must be key.
Absolutely critical, the claimant's own personal testimony. They need to articulate, clearly and credibly, why they believe accepting this ID would be an act of apostasy, a violation of their duty to God alone, as per Exodus 20. They need to convey the genuine spiritual peril they feel.
That intensity, that conviction, rooted in Scripture and may be supported by theological context, that's what the court has to engage with under that Eweida standard of genuine and deeply held.
Exactly. That's how you clear the first hurdle and establish the belief as legally protected. Right, so once we've established that the belief is protected under the Equality Act, we move to the main legal attack, indirect discrimination. This is Section 19 of the Act.
And you said earlier this is likely the strongest route, rather than, say, direct discrimination. Why is that?
Because it's very unlikely the government would write a policy saying, Christians holding this specific view are banned from X. Direct discrimination needs that explicit targeting because of the protected characteristic.
Okay.
Indirect discrimination focuses on the effect of a seemingly neutral rule. The classic example is a height requirement for a job that disproportionately excludes women. The rule applies to everyone, but it disadvantages a specific group.
So the digital ID rule applies to everyone.
Yes, but the argument is that it puts people holding this specific religious belief at a particular disadvantage. Section 19 requires proving 4 things. Let's walk through them.
Go for it.
First, there has to be a provision, criterion, or practice. Let's call it a PCP. Here, the PCP is the mandatory requirement to have and use the digital ID for certain services or activities. Simple enough.
Okay, the rule itself.
Second, you have to show that this PCP puts, or would put, people who share a protected characteristic in this case. Christians holding this specific mark of the beast belief at a particular disadvantage compared to people who don't share that characteristic.
Right, the disadvantage part. Let's really nail that down. What is the specific disadvantage or burden this policy imposes on this group?
The disadvantage is the absolutely impossible choice the policy forces on them. It's a catch-22 mandated by the state.
How so?
They face 2 unacceptable outcomes. Option 1, comply, get the digital ID. But in doing so, they violate their deepest held religious convictions, betray their allegiance to God, and, in their sincere belief, risk eternal spiritual consequences. That's profound spiritual and psychological harm.
Okay, that's one side of the impossible choice.
Option 2, refuse, uphold their faith. But the consequence is potentially catastrophic exclusion from modern life. If the ID is needed for banking, jobs, travel, healthcare access, refusing it means being cut off from the essentials of participating in society.
Wow. So it directly mirrors the economic exclusion described in Revelation 13, not being able to buy or sell.
Precisely. That parallel is legally powerful. This forced choice, violate your soul or face societal exclusion, is the particular disadvantage. It's a burden the general population simply doesn't face when complying with the ID requirement. That's the core of the indirect discrimination claim.
That frames it incredibly strongly. It's not just an inconvenience. It's presented as an existential threat to either their spiritual integrity or their ability to function.
Yes, and once you establish that disadvantage, both for the group and for the individual claimant, that's the third element of Section 19, showing the claimant personally suffers this disadvantage, then the legal burden dramatically shifts.
Shifts onto the government.
Entirely. The fourth element of Section 19 is that the government must justify the PCP. They have to prove that the mandatory digital ID policy is a proportionate means of achieving a legitimate aim.
Okay. Proportionate means legitimate aim. Let's unpack that justification defense. What counts as legitimate?
Legitimate aims are usually things the courts readily accept. National security, preventing fraud, crime detection, perhaps administrative efficiency, ensuring access to services smoothly. The government will definitely argue the ID serves these aims.
So they'll say, look, we need this for security. It makes things efficient.
Absolutely. But the real battleground is proportionality. This is where the court has to perform a balancing act.
Balancing what against what?
Balancing the importance of the government's legitimate aim, for example, security, against the severity of the discriminatory impact on the religious group. How much does the ID actually improve security versus how badly does it impact the believer's fundamental right under Article 9 to manifest their religion?
So it's not enough for the government just to say security.
Not at all. They have to show the measure is proportionate. And crucially, part of proportionality is asking, is this measure necessary? Is there a less intrusive way to achieve the same aim?
Ah, okay. So if the government makes its case for security and efficiency, how does the challenger fight back against that justification?
They attack the proportionality, specifically the necessity aspect. The argument becomes, this mandatory universal digital ID is not the least restrictive means available to achieve your stated goals of security or efficiency.
The least restrictive means. That sounds like a key legal phrase.
It is. It comes up repeatedly in human rights law. Our sources reference cases like R. Begum v. Secretary of State, the case about school uniform and religious dress, which underscored this principle. If state action interferes with a fundamental right, the interference must be minimized.
So the claimant's legal team needs to propose actual alternatives.
Absolutely. They need to put concrete, viable, less discriminatory options on the table, they'd ask. Why couldn't the government offer a secure, verifiable, paper-based alternative ID specifically for those with registered religious objections?
Like they do for some other things.
Maybe. Or why not a complete religious opt-out system, perhaps requiring occasional in-person checks or using different verification methods for those individuals? The moment the claimant can show a plausible, less intrusive alternative exists that still reasonably achieves the government's legitimate aims.
Then the government's argument that the current mandatory digital policy is proportionate starts to crumble.
Exactly. The government's justification fails if the measure goes further than necessary, if it imposes this terrible choice when a less harmful alternative could work.
We've seen the legal system find ways around these things before, haven't we? Like conscientious objection in wartime, or recently with COVID vaccine exemptions in some contexts. It shows accommodation is possible.
Precisely. Precedents involving conscientious objection, like R. McConnell v. Registrar General, which dealt with conflicts around gender recognition, demonstrate the court's ability and arguably duty to find ways to accommodate deeply held convictions when state policy creates a fundamental conflict.
So the argument is, if the state can accommodate moral objections there, it must accommodate a theological objection concerning something as profound as eternal salvation here.
That's the logic. The existence of any feasible non-digital alternative, even if it's slightly less convenient or efficient for the government, powerfully undermines the claim that this specific, highly intrusive digital ID policy is truly necessary and therefore proportionate.
Okay, so indirect discrimination is the main weapon here. But you mentioned other claims, supplementary ones. Let's talk about those because I think this is where we get into the real human cost, the suffering, and maybe, crucially, the potential for compensation.
Exactly. These supporting claims can strengthen the overall case, but importantly, they directly address the distress and hardship caused, which is vital for seeking damages. Let's briefly touch on direct discrimination again, Section 13 of the Equality Act.
We said it was less likely, but when might it apply?
It would apply if the government's actions or messaging started to explicitly target or penalize this group. Imagine, for example, public statements labeling people who refuse the ID on these grounds as faith-based objectors, or maybe dismissively as conspiracy theorists, and then subjecting only them to extra scrutiny, fees, or deliberately slow processing for alternatives.
So treating them less favorably because of their stated religious belief.
Precisely. If there's evidence of that kind of targeted negative treatment based on the religious objection itself, then a direct discrimination claim becomes viable.
But you feel the more likely scenario, and perhaps more powerful in terms of demonstrating harm, is harassment under Section 26.
Yes, I think harassment is potentially very significant here. Section 26 defines harassment as unwanted conduct related to a relevant protected characteristic here, religion or belief, which has the purpose or effect of violating the claimant's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them.
Okay, unwanted conduct, violating dignity, hostile environment. Let's make that concrete. What kind of actual experiences, what kind of coercive enforcement or public pressure related to refusing the ID would count as harassment in court?
Think about the day-to-day reality for someone refusing the ID. They go to access a public service, maybe renew their driving license online. They can't because it requires the digital ID. They phone up, explain their religious objection, and the person on the other end says something dismissive like, oh, one of those. Look, just get the ID. Stop making trouble. That's unwanted conduct related to their belief, creating a humiliating environment.
Okay, that's one instance.
Yep.
Harassment often implies something more persistent.
It does. Imagine this happening repeatedly. Trying to access healthcare, maybe they need a specific hospital referral, but the system requires the digital ID for booking. They're denied, maybe told they can't see the specialist without it. They try to sort out benefits, same issue. Try to apply for a job that requires digital verification, blocked again.
It's a pattern of exclusion and dismissal based on their refusal, which stems from their faith.
Exactly. That constant encountering of bureaucratic walls, coupled potentially with dismissive or contemptuous attitudes from officials, is the unwanted conduct. It systematically degrades their dignity and creates an intimidating and hostile environment where they feel punished and marginalized simply for adhering to their faith.
So the denial of essential services itself becomes a form of harassment if it's linked to their religious refusal and creates that negative environment.
Yes, especially if it's persistent and has a significant impact on their life. And it gets worse if there's wider societal pressure. Imagine government information campaigns, maybe posters or online ads that don't name the claimant but broadly caricature ID refusers as Luddites or extremists or somehow socially irresponsible.
That contributes to a hostile social environment, making them feel ashamed or afraid.
Absolutely. That public shaming, even if indirect, combined with the practical, systemic exclusion from services, that's a powerful combination that very clearly falls under the definition of harassment in Section 26. It violates dignity fundamentally.
And this ties back to the Human Rights Act, too.
Strongly. Remember, Article 9 protects the manifestation of belief. The state has a duty not just to refrain from interfering itself, but also to take reasonable steps to protect people from having their rights violated in this way. Allowing a system where someone is constantly degraded or excluded because they are manifesting a sincere religious belief could itself be an Article 9 violation. There are precedents, like Kokkinakis v. Greece, where the European Court emphasized that states must be careful when restricting religious practices, especially those deeply rooted in Scripture, like end-times beliefs. Restrictions must be truly necessary in a democratic society, and allowing systematic harassment certainly wouldn't meet that test.
So the message is clear. The suffering, the distress, the humiliation caused by being excluded or demeaned because of this belief. It's not just unfortunate, it's legally recognized harm, and the law provides a route to seek redress, including potentially significant compensation.
That's the crucial link. The harassment claim directly opens the door to damages for that very real suffering.
All right, let's get down to the nuts and bolts. How does someone actually bring this case forward? And the part everyone wants to know, what can they actually get if they win? This is the payoff section, focusing on the relief and, yes, the compensation for potentially being harassed or discriminated against.
Okay, the legal venue really depends on how the discrimination manifests. If the refusal of the ID leads to a specific tangible loss, say, someone gets fired because they can't meet a new digital verification requirement for work, or a bank actually closes their account, the claim would likely start in the county court, or, if employment-related, an employment tribunal.
Okay, for specific losses.
But if the goal is bigger, if the claimant wants to challenge the entire policy, the legality of the mandatory digital identity framework itself as being inherently discriminatory that requires a different route, that's judicial review in the high court.
Judicial review, that's where judges scrutinize government actions and policies.
Exactly. It's where you ask the high court to declare the government's policy unlawful because it breaches the Equality Act or the Human Rights Act.
Okay, now, regardless of where the case is heard, what kind of evidence, beyond the personal testimony and biblical points we discussed, do they need to really strengthen this kind of, let's face it, unusual claim?
You need strong supporting evidence to counter any attempt to dismiss the belief as purely personal or irrational. We already mentioned expert affidavits from theologians. That's crucial for establishing the belief's grounding within a recognized religious tradition.
Right, the academic backing.
Second, you need powerful comparator data and legal precedents. You need to show the court examples of where UK law already makes accommodations when neutral rules clash with protected characteristics, especially religion.
Like the Sikh turban case.
Exactly. Our sources point to Manla v. Dawal Lee. That was the case where a Sikh schoolboy was refused admission because the school had a no-hats policy, and he needed to wear a turban for his faith. The House of Lords ruled the policy was indirectly discriminatory.
Because it applied to everyone, but had a negative impact on Sikhs who had a religious requirement.
Precisely. The legal argument here is, if the law requires accommodation for a religiously mandated item of clothing, like a turban, surely it must also require accommodation for a deeply held conviction about one's relationship with God and eternal salvation, which is arguably even more fundamental. You use precedents like Mandla to show that making exceptions for genuine religious requirements is standard legal practice.
Okay, that makes sense. Now let's get to the really juicy part. The remedies. If the claimant succeeds, what do they actually win? This is about more than just a moral victory, right? It's about tangible results, especially that compensation angle.
Absolutely. The remedies can be multi-layered and significant. First, on the policy level, if it's a successful judicial review, the court can issue a declaration of unlawfulness, basically saying the government's current mandatory rollout plan is illegal as it stands.
Okay, that's big picture.
For the individual claimant, the court can grant an injunction. This would be a legally binding order telling the government or specific public bodies like the NHS or DVLA that they cannot enforce the digital ID requirement against that specific person.
So a personal shield protecting them from the policy.
Yes. And potentially, The court could push for, or the outcome could necessitate, a broader policy amendment forcing the government to build in a proper, workable, religious opt-out mechanism for everyone in that situation.
That's the systemic change. But let's talk money, the compensation. If they prove they suffered indirect discrimination, or especially harassment under Section 26, what financial remedies are available?
This is where the focus on harassment really pays off, legally speaking. A successful claimant is entitled to damages for injury to feelings. This is compensation specifically for the distress, anxiety, humiliation, and upset caused by the discriminatory act or the harassing environment.
Injury to feelings. How on earth do courts put a price tag on that? You mentioned a cap earlier, around 9,000 pounds under the Equality Act. Is that right?
That figure might be related to specific tribunal limits or older guidance. Actually, for injury to feelings in discrimination cases, the courts use established guidelines known as the Vento bans. There's no fixed upper cap, like in some other areas of law.
Vento bans. Okay, tell me about those. How do they work?
They set out 3 broad brackets for compensation, depending on the seriousness of the discrimination and its impact. These bands are updated periodically for inflation. The lower band currently, roughly speaking, around 1,200 pounds up to about 11,700 pounds, is typically for less serious or one-off incidents of discrimination. Maybe a single insulting comment or a minor instance of disadvantage.
Okay, the lower end.
The middle band, running from about 11,700 pounds up to roughly 35,200 pounds, is for cases that are more serious but don't meet the criteria for the highest band. This is where most substantial discrimination cases tend to fall.
Right.
And then there's the upper band. This is for the most serious cases. We're talking about 35,200 pounds up to potentially around 58,700 pounds, although in truly exceptional circumstances, it could theoretically go higher. This band is reserved for cases involving a lengthy campaign of discrimination or harassment, severe psychological impact, or where the victim's life has been significantly affected.
Wow. Okay, so 58,700 pounds is a serious potential figure. Thinking about our scenario, someone systematically excluded from banking, healthcare, travel, maybe facing public ridicule or dismissal from officials over months or even years because of their faith, where might that fall?
A good lawyer would absolutely be arguing for the upper band in that kind of scenario. They would emphasize the sustained nature of the exclusion, the cumulative psychological distress, the anxiety, the impact on the person's ability to live a normal life, the profound violation of their dignity linked directly to their core religious identity.
So the potential compensation isn't trivial. It's designed to reflect genuine significant harm caused by the state's failure to accommodate.
Absolutely. It's not punitive damages, generally, but compensatory, intended to acknowledge and compensate for the real suffering caused by the unlawful discrimination or harassment. This potential for substantial damages under the Vento bans is a key part of holding public bodies accountable.
And on top of injury to feelings, could they claim for actual financial losses too?
Yes, if they can prove them. If the discrimination directly caused them to lose earnings, incur specific costs, maybe having to pay for private services they were denied publicly, those financial losses can be claimed separately in addition to the injury to feelings award.
Okay, so the remedies are potentially quite powerful, both in stopping the policy's application and in compensating for the harm done. Are there any other precedents that suggest courts will protect these kinds of sincere, even if controversial, beliefs?
Well, the Levy-Asher's baking company case, the gay case, is relevant. Although the final ruling from the Supreme Court focused on compelled speech, the earlier stages and the general legal discussion reinforced the principle that sincerely held religious beliefs, even those considered discriminatory by others, are generally protected. The law protects the sincerity of the conviction. And while UK courts are distinct, there's arguably some persuasive influence from major U.S. cases like Burwell v. Hobby Lobby, where the U.S. Supreme Court upheld faith-based exemptions from certain government mandates. It contributes to a background legal culture where accommodating deep religious objections is seen as a necessary aspect of protecting freedom of conscience. Okay, let's be realistic, though. Bringing a case like this is tough. We need to look squarely at the government's likely defense strategy and the hurdles the claimant faces.
Absolutely. What's the biggest weapon the government will likely use to try and shoot this claim down?
Their primary attack will almost certainly be on the nature of the belief itself. They'll try to argue it doesn't meet the Granger criteria specifically, that it's not worthy of respect in a democratic society.
How would they argue that?
They might try to frame it as irrational. as unfounded apocalyptic paranoia, perhaps linking it implicitly to anti-government or anti-technology sentiment rather than genuine religious conviction. They might suggest it's not a real theological belief, but a fringe interpretation being used for political ends. Their goal is to persuade the judge that this belief is so far outside the mainstream it doesn't deserve legal protection.
And that feels like a major risk, doesn't it? Centering a case on something like the mark of the beast and eternal damnation in a secular court, won't the judge just dismiss it as, well, crazy?
It's definitely the claimant's biggest vulnerability, but the legal strategy is designed precisely to counter this. The focus has to be on sincerity, cogency, and canonical rooting. The lawyers don't ask the judge to believe in the mark of the beast. They ask the judge to accept, based on the evidence, the claimant's testimony, the theological experts, the biblical citations, that the claimant genuinely, sincerely, and coherently believes this, and that this belief stems directly from core Christian scripture.
So lean heavily on the Eweida principle. The court assesses sincerity, not orthodoxy or rationality.
Exactly. Unless the belief promotes violence or hatred or directly harms others' fundamental rights, which simple refusal doesn't, courts are generally very reluctant to deem a belief based on major religious texts as unworthy of respect. Dismissing it is legally difficult if the sincerity is established.
Okay, so that's challenge number one, attacking the belief itself. What's the second big defense pillar for the government?
National security and public order. This is always the government's trump card in rights-based arguments. They will argue that a universal, mandatory digital ID is absolutely essential for national security, counterterrorism, preventing serious crime, maybe ensuring economic stability by tackling fraud.
And they'll say that these collective needs outweigh the individual's religious objection.
Precisely. They'll argue that allowing opt-outs, even for sincere religious reasons, would create vulnerabilities that criminals or terrorists could exploit, or would make the whole system unworkably inefficient and costly.
How does the claimant counter that? National security sounds pretty compelling to a judge.
This is where the proportionality test and the least restrictive means argument become the claimant's crucial counterweapon. Yes, national security is a legitimate aim, but is this specific measure proportionate?
Back to that balancing act.
Yes. The burden shifts back to the government. They can't just assert national security. They have to provide concrete evidence to the court demonstrating why this specific mandatory digital system is necessary, and crucially, why no less intrusive alternative could reasonably achieve the same security objectives.
So the claimant's team keeps pushing those alternatives. The secure paper ID, the tailored opt-out system.
Exactly. They force the government to prove not just that digital is convenient or better, but that any non-digital alternative is dangerously inadequate or completely unworkable. If the claimant can show plausible, less discriminatory alternatives exist that still offer a high level of security,
then the government's claim that the mandatory digital ID is necessary and therefore proportionate weakens considerably. They haven't used the least restrictive means.
Correct. It becomes much harder for the government to justify the severe impact on the claimant's religious freedom if less impactful ways to achieve security are available.
Okay, so pulling it all together, what are the realistic odds of success here? Is this a long shot or a genuine possibility?
I'd say the sources suggest moderate odds for success, maybe leaning towards viable if argued correctly. It's definitely not a slam dunk, but it's far from impossible.
What makes it viable?
The key is framing it meticulously as indirect discrimination impacting a genuinely held, scripture-based belief, leading to significant disadvantage, and leveraging that proportionality argument relentlessly. Recent case law, like the four-stater VCGD Europe case concerning gender-critical beliefs, shows that UK courts are willing to grapple with and protect beliefs that might be considered controversial or non-mainstream, provided they meet the legal tests for seriousness and coherence.
So there's flexibility in the system for these kinds of nuanced convictions.
There is. If the claimant can robustly demonstrate their sincerity, the link to scripture, the disadvantage caused by the policy, and crucially, point towards workable, less restrictive alternatives, they have a solid fighting chance in the high court. Especially if they can also build a strong case for harassment, opening up those significant damages we talked about. #tagoutro.
Wow. Okay, this has been an incredibly detailed deep dive. We've mapped out the entire legal architecture, the Equality Act 2010, the Human Rights Act 1998, key cases like Eweida, Granger, Mandela. It really shows the sheer level of legal thinking and evidence needed to potentially challenge a major government policy based purely on a specific, deeply personal, theological interpretation. Amazing how scripture reading can lead straight into a high court battle.
It really is. And I think the core takeaway for you, the listener, has to be the surprising power of sincerity in UK discrimination law. The system is designed, at least in principle, to protect your genuinely held, coherent conviction, even if it's complex, interpretive, or not shared by the majority, provided it meets those legal thresholds we discuss.
The focus isn't on whether the belief is right, but whether it's real for the person holding it.
Exactly. And because of that, the legal pressure shifts heavily onto the government. They carry the burden of proving their policies are proportionate, non-discriminatory, and use the least restrictive means possible when fundamental rights are engaged.
And if they fail that test,
If they fail, not only can the policy itself be challenged, possibly forcing amendments like religious opt-outs, but the individual who suffered discrimination or harassment can seek substantial financial compensation potentially into that upper Vento band we discussed for the distress and hardship caused by the state's failure to properly accommodate their faith.
that compensation element is so important, isn't it? It turns it from just a theoretical legal principle into a potential real-world remedy for actual suffering and exclusion.
It makes the rights tangible, and it brings us to a final sort of provocative thought for you to mull over. We've established that a successful legal challenge could compel the government to implement the least restrictive means possible. Now imagine they had to provide a nationwide, secure, reliable, verifiable, non-digital alternative identity system specifically for religious objectors, sufficient to meet security needs acceptable to a court. Given the complexities of modern identity verification, fraud prevention, and linking to essential services, what would that intricate, national, potentially paper-based or token-based system actually look like in practice? Designing that might be the hidden, complex challenge of upholding this specific religious freedom in our increasingly digital age.
Fascinating thought. What does accommodation truly mean when the default becomes digital? Lots to think about there.